While delivering its verdict on a public interest litigation seeking Supreme Court directions to remove parallel courts, the apex court ruled that Sharia courts and fatwas, while they're not constitutional, they are not illegal either. Which means a Muslim is free to follow the Sharia and abide by a fatwa as long as it doesn't violate his or her fundamental rights.
On the 6th of June 2008, a 28-year-old Muslim woman, Imrana, was raped by her father-in-law near Muzaffarnagar in Uttar Pradesh. Shariat law regards sexual relations with father and son as incestuous. After several levels of Islamic legal opinion, Imrana's marriage to her husband was nullified.
The distinction between rape and adultery was not made in Imrana's case, which formed the crux of Delhi-based advocate Vishwa Lochan Madan's PIL, challenging the writ of Sharia courts and the fatwas issued by them. Now, though these courts and the writ that they have is not legally binding, still a majority Muslim population that follows the Shariat takes their word as the final word.
They have said fatwa can be given only when the concerned party approaches. This is they have streamlined the procedure, and they have not declared that the Shariat courts are unconstitutional or they cannot run. The writ petition was that these should be stopped from running parallel judiciary. Court said they are not running parallel judiciary, therefore that cannot be stopped, and they have not allowed the writ petition, they have disposed it off.
The Supreme Court called the establishment of Sharia-based courts laudable, however clarified that they did not have any legal character. A fatwa is merely an opinion, not something that is enforceable by law. If anyone tries to enforce it, then that act would be considered as illegal. The Supreme Court also said that the perception that these courts are running a parallel judicial system is misconceived.
Essentially, the Supreme Court has dealt with the specific case mentioned in the PIL. Imrana's case was referred to religious leaders by a third party. The Supreme Court has ruled that only aggrieved parties can approach the Shariat court, that a third party can seek a fatwa only when the issue impacts the community as a whole.
Though the Supreme Court judgment has not made any radical changes in the functioning of the Sharia court, it has perhaps for the first time removed any ambiguity over the ambit of their writ and the definition of fatwa. In New Delhi with camera person Wahid Beg, Jaskirat Singh Bawa for Headlines Today.